Hello viewers. Contingent contracts. What do we mean by contingent contracts? The Indian Contract Act 1872 makes provision for contingent contract. Section 31 of the Act specifically defines what is contingent contract and says that a contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. The section itself gives the illustration, which essentially means that there is a contract which is to be fulfilled upon the happening or not happening of some event. The crux of section 31 is that in contracts in general, the promisor binds himself to the performance in any event without any such condition. Go back to the definition of offer and acceptance, specific and unconditional. Just in contrast, in contingent contract, the performance depends upon the happening or non-happening, one, in future, two, of some event. Thus, the dependence on the future event, mark this, dependence on the future event distinguishes a contingent contract from other contracts. The event which is collateral must be uncertain. That is, if bound to happen, it is not contingent. The collateral event, incidental event to the contract. The most common example of such event is the contract of insurance. Essentially, the contract is of insurance. But in substance, what it is? The owner is to be indemnified in case of accident. Now, is an accident a certain thing? The answer is no. The happening or not happening of an accident is uncertain. The main contract is the contract of indemnity. It is dependent on the accident. Such contracts are in law known as contingent contract. Section 32 to 36 of the Contract Act prescribe rules regarding contingent contract, meaning thereby when the contingent contract dependent on the happening or not happening of an event is to take place and when it becomes void. Section 32 speaks of contract contingent on happening. Look at the section. What does it say? Contingent contracts to do or not to do anything. If an uncertain future event happens, cannot be enforced by law, unless and until that event has happened. If the event becomes impossible, such contracts become void. Look at the section. What does it say? Uncertain future event, something to do or not to do on the happening of it. Question is when it can be enforced. Law says it cannot be enforced unless and until that event has happened. That is one situation. If the event happens, it becomes enforceable. If the event becomes impossible, the contract becomes void. And that is why one of the reasons that they are termed as contingent contract. Look at the illustration given in the section itself, which says that A makes a contract with B to buy B's horse if A survives C. This cannot be enforced by law unless and until C dies in A's lifetime. Section 33. This section contemplates the contingent contracts which are based on non-happening of an event. Please remember that the most important thing is uncertain future event and the happening or not happening of it. Look at the section. Section 33 says contingent contract to do or not to do anything if an uncertain future event does not happen can be enforced when the happening of that event becomes impossible and not before. In short, if the contingent contract is dependent upon the non-happening of an uncertain future event, then it can be enforced only when the happening of that event becomes impossible and not before. The simple illustration given in the section itself says that when there is agreement to pay money if ship doesn't return and the ship is sunk, the contract can be enforced when the ship is sunk. Section 34 speaks of contingent contract based on individual act and what happens to such contracts. It says if the future event on which a contract is contingent is the way in which a person will act, the singer, at an unspecified time, the event shall be considered to become impossible when such person does anything which renders it impossible that he should so act within any definite time or otherwise than under further contingencies. The section itself gives example that A agrees to pay B a sum of money if B marries C. Now C married D. The marriage of B and C must now be considered impossible, although it is possible that D may die and that C may afterward marry B. But such contingencies are not contemplated in law. The moment B marries C, Section 34 comes into play. B has rendered himself incapable of acting in a manner which A wanted, and therefore that would be the result of the contract. Section 35 speaks of the happening of an event within fixed time. It says contingent contract to do or not to do anything. If specified uncertain event happens within a fixed time. So here fixed time is the essential element. Becomes void if at the expiration of the fixed time such event has not happened, or if before the time fixed such event become impossible. You can as well continue with the earlier example that marriage must take place within 1 year, and within 1 year B marries D, or B allows 1 year to pass and does not marry. In both the situation, the contract becomes void. Part 2 of Section 35 contemplates the situation of non-happening of an event within the fixed time and says contingent contract to do or not to do anything if the specified uncertain event does not happen within a fixed time may be enforced by law when the time fixed has expired and such event has not happened, or before the time fixed has expired if it becomes certain that such event shall not happen. You can continue with the same example of marriage. Section 35 gives illustration of what is stated in Section 35. A promises to pay B a sum of money if certain ship returns within a year. The contract may be enforced if the ship returns within a year and becomes void if the ship is burnt within a year. Second example given in the statute is A promises to pay B a sum of money if certain ship does not return within a year. The contract may be enforced if the ship does not return within a year or is burned within the year. The last part of the contingent contract and says contingent contract on impossible event. Section 36 says contingent agreement to do or not to do something if an impossible event happens are void. Whether the impossibility of the event is known or not to the parties to the agreement at the time when it is made. See very clearly, law doesn't want you to do an impossible thing. So essentially, if contingent contract is based upon an impossible event, it says it is void. There may be a situation that impossibility is either known or not to the parties. Law says it is immaterial whether it is known or not known. Law simply does not want you to do what is impossible. And similarly, the section itself gives an example that A agrees to pay B rupees 1000 if two straight lines should enclose a space. You can very well see that the agreement is void. Another example also, that A agrees to pay B rupees 1000 if B will marry A's daughter C. C dies, the agreement is void.